Good morning, everyone. Welcome to this weekly episode of The Future of Europe. Today we are welcoming Solenne Wald. First of all, thank you for your presence. And you are here to talk about the CGU, the case C4715, which is named Celina Affum vs. Pas-de-Calais. Why do you want to talk about this case today?
So first of all, good morning, Louise, and thank you for having me today. More than 3,000 migrants died trying to reach Europe at sea in 2021, twice as many as in 2020, the UN announced on 2022. They want alternatives to these desperate and dangerous escapes. According to the UN High Commissioner for Refugees, the COVID-19 pandemic and subsequent border closures have had an impact on migrant flows, with many refugees and migrants turning to smugglers to try to reach Europe anyways. Most sea crossings are made in crowded, inflatable boats that are in poor conditions, and many of these boats deflate or capsize, killing the occupants.
Okay, and how do you actually define a migrant?
So according to Article 3 of Directive 2008-115 EC, an irregular migrant is a person who, owing to irregular entry, breach of conditions of entry, or the expiring of the legal basis for entering and residing, lacks legal status in a transit or a host countries. In the EU context, a third country national present on the territory of the Schengen area who does not fulfill or no longer fulfill the condition of entry as set out in the regulation 2016-399 of the Schengen Border Codes or other conditions for entry. The term irregular is preferable to illegal migrants because the latter carries a criminal conditions. Entering a country in an irregular manner or staying with an irregular status is not a criminal offense, but an infraction of administrative regulations.
Okay.
So, sorry.
It's okay, go ahead.
Apart from this, juridically or ethically, an act can be legal or illegal, but a person cannot. So, thus, more and more the term migrants in an irregular situation of migrants of irregular status is preferred. Irregular entry are offences in almost all member states, European Union member states. It's often punishable with custodial sentence. Under certain conditions, a person can also be detained within the written procedures.
Okay, thank you so much for your explications. Could you just remind us the facts of this case?
Yes, of course. So in March 2013, a Ghanaian national, Celina Affum, was intercepted by French police at Coquel, the entrance of the Channel Tunnel, while transiting through French territory on a bus from Belgium to the UK. She was detained for illegal entry pursuant to Article L621/2 of the Code of Entry and Residence of Foreigners and Asylum Law. But the prosecutor decided to take no further criminal proceedings against her. The prefect of the Pas-de-Calais made an order deciding to transfer her to Belgium in accordance with a readmission agreement between France and Belgium and the Benelux countries. He also ordered her administrative detention for a period of 5 days, pending removal, which was later extended by a judge of the High Court of Lille. We can ask ourselves, is French legislation allowing for the imprisonment of a third country national who has entered a territory of a member state illegally compatible with the return directive?
That's actually a very good question. And do you know how do EU law gives an answer to this question?
Yes, of course. So Article 2.1 and Article 3.2 of Directive 2008/115 EC of the European Parliament and of the Council of the 16th December 2008 on common standards and procedures in member states for returning illegally staying third country nationals must be interpreted as meaning that a third country national is staying illegally on the territory of a member state and therefore falls within the scope of that directive when, without fulfilling the condition for entry, stay or residence, the person passes in transit through that member state as a passenger on a bus from another member state, forming part of the Schengen area and bound for a third country member state outside that area. Moreover, Directive 2008/115 must be interpreted as preclude legislation of a member state, which permits a third country national in respect of whom the return procedure established by that directive has not yet been complete or to be imprisoned merely on account of illegal entry across an internal border resulting of a illegal stay. That interpretation also applies where a national may be taken back by another member state pursuant to an agreement or arrangement within the meaning of Article 6.3 of the directive.
Okay, thank you so much. And do you know what is the opinion of the Advocate General on this Affum case?
Yes, thank you for your question. So the CGU's finding was preceded by Advocate General Spunzar's opinion, in which he found that the return directive applied to Mrs. Affum as a person who illegally crosses the border with no right to reside in the territory of the member state concerned. He rejected the argument of the French authorities that it was inapplicable in relation to rules on the crossing of external borders and the movement of third country nationals between member states. For a number of reasons similar to those raised by the court, namely the geographical crossing of a member state and the fact that Ms. Affum was exiting the Schengen area. Having examined the case law, the Advocate General considered that there were two situations in which the directive permitted national legislation which punished illegal stay on a third country national with a term of imprisonment. First of all, where the return directive was being applied, but the person continued to stay illegally without justification, for example, in the Ashok Babian case. Or, second, where a person who was returned in accordance with the directive re-enters the territory of that member state in breach of an entry ban, for example, in the Silage case. So none of this situation was applicable to Mrs. Affum, and therefore a third country national in her position could not be imprisoned solely on the basis of illegal stays in the territory of a member state.
Okay, and finally, what is the link between this case and the future of Europe?
So, while on the one hand, the decision of the Court of Justice not to directly address the fundamental rights agreement may be welcomed by national administration, on the other hand, it cannot be excluded that another international human rights court will have a say on the same decisions. However, in this case, the court did not seem to be particularly concerned with these circumstances, as it main purely seems to be ensure a speedy development of the return procedure and foster cooperation between national authorities. It is perhaps no coincidence that this decision was adopted in the midst of the process of adopting the new European Coast Guard and Border Guard regulation, which make a considerable effort to increase the efficiency of the return procedures.
Well, thank you so much, Solenne. Our episode is coming to an end. Thank you so much for listening to us. Thank you again, Solenne, and I'll see you guys next week for the next episode. Thank you.